unite for our rights. Good morning, dear friends and viewers. We are the members of OBC Rights. We want to give a short explanation on what is this UGC regulations, that is UGC Promotion of Equity in Higher Education Institutions, Regulations 2026. Actually, these regulations were brought in at the instance of the Supreme Court on the petitions filed by the mothers of Rohit Vemula and Payal Tadvi. You may aware that these two young boys who are doing PhD and who are doing medical, they committed suicide because of the humiliations and harassments in the campuses of the higher education institutions in Hyderabad and Mumbai. There were so many deaths, so many students who enter in the higher education institutions, especially funded by the government of India. They come out due to the humiliations, pressures, criticism, and so on and so forth, meted out or inflicted by their own co-students or faculty members and staffs. As a result of the petition filed by the mothers of the students who lost their lives out of these harassments, Supreme Court in 2025 September directed the UGC to come out with the regulation to prevent such occurrences in the higher education institutions controlled by the UGC. So UGC brought in this anti-discrimination regulation 2026 only to protect the OBC and SC students from unjustifiable harassments, ridiculing, teasing, differential treatment, and etc. So, a regulation which was brought at the instance of the Supreme Court by a higher elite body like UGC, it was questioned by so many students and other sects belonging to the advanced countries in North India, and there were so many agitations. And social medias were flooded with criticism, unnecessary assault, huge allegations, and etc. But it remained, the UGC actually stuck to the regulations. Unfortunately, the Supreme Court of India in January 2026, January 29th of 2026, stayed these regulations, saying that this regulation will pave the way for gap between communities and there is a scope for misuse. The order is a little strange. See, everywhere, every law, including the BNS, including the SC/ST/PO Act, including TADA, POTA, and every act is prone for misusing. Every act may be misused. It is the institution, it is the bounden duty of the institution to see that they are not misused. Then there are courts, so many courts, district court, higher court, high court, Supreme Court, etc. It is for them to prevent the misuse. But the order is a little strange. Somehow we wish to place it on record that the OBCs are treated in an indifferent way, and some or otherwise we feel that there is some sort of differential treatment. If you start from 1951, a case called Shenbagam Duryarajan case, in which the admission given to a student on the basis of the reservation was cancelled, then later on it was restored at the instance of the past Chief Minister K. Kamaraj, and the amendment, first amendment in 1951 came, which paved the way, that is 15-4, paved the way for reservation of OBC students in education institutions. Then yet again, in 1992, when Mandal Commission was implemented and 27% reservation was given, it was also protested with violent agitations and etc. Again, as usual, it was challenged in the Supreme Court. A constitution bench consisting of 9 judges heard the case. Out of 9, 6 confirmed the 27%, but strangely they too imposed a restriction called a creamy layer only for OBCs. This is not for any other reserved communities. Then if you go back again, EWS in Indira Sahani case, it was categorically stated that the reservation cannot be given on the basis of economical parameter. Despite of that, economically weaker section 10% was given, and out of 5 judges, 3 judges overruled the observations or the directions or the judgment given in Indira Sahani case. It is quite strange. Again, now in 2026, a regulation 2026, which has been issued, notified at the instance of the Supreme Court on the petitions filed by the aggrieved parties, it has been stayed on a strange reason. The MLAs, MPs and ministers who took oath on office on the Constitution of India, they never complied with the provisions of the Constitution, especially 14, 15, 1 subclass 1 to 6 or 16 subclass 1 to 6 or 340 or 105 amendment. Dear friends, we are never provided with any of the guarantees given in the Constitution of India. Unfortunately, the higher courts, that is High Courts and Supreme Court of India, also kept calm or maintained calm when we were deprived of our constitutional rights for 42 years. And even for taking caste census as mandated in Constitution of India provision 340, we are still struggling. The governments as also the higher judiciary should or explore the possibilities of eliminating these lacunas, or they should seriously consider the deprivation of our rights. Thank you.